Hi, can everybody hear me? Cool. Welcome, thank you for coming. This is part one of our two-part seminar about the upcoming Renters' Rights Act. It's made its way through Parliament at the minute without too much trouble. So it looks like it's going to come into law, I think, and I'll be corrected, probably in early 2026, if not late 2025. What you will have heard about it, or what most people who aren't lawyers will have heard about it, is that Section 21 is going away. But if you get into the detail of it, a lot more is going to happen. Fixed term tenancies entirely seem to be going away. That is going to shift the balance, we hope, between landlord and tenant, making it more on the tenant to decide how and when their tenancy comes to an end. On top of that, there's going to be new duties on local authorities to start to enforce some of the regulations that we've known for a long time have been sitting dormant. It's going to make it easier for tenants to challenge rents, though how easy we're not sure, and how practical that is, we're not sure. On the other hand, the new law is also going to introduce a slew of new grounds for possession that I'm sure is going to keep the county courts busy once Section 21 goes away. For this section, we're going to focus on the changes to the grant to the tenancy and the life of the tenancy. And then you'll have to join us next week to talk about how those tenancies might come to an end or how we can stop them coming to an end. We're very lucky to have with us David Cowan, Dominic Preston and Cara Hall to take us through these changes. David, as well as being a member of our housing team, is the Journal of Law and Society Professor of Socio-Legal Studies at Cardiff University. Sorry. We get a commission every time we say it. And on top of that, sits as a residential property tribunal judge and a DDJ. So he's been up on this stuff much longer than we have. So it's a pleasure to have him here. He's going to be covering discrimination, the new database, setting rents, and licensing of HMOs. Dominic over here, very cheesy to say, but needs no introduction, and so I'm probably not going to give him much of an introduction. If you're just meeting Dominic now, he's a very senior member of our housing team. His housing practice is centred on homelessness, allocations, disputes concerning residential premises, rented or leasehold, and he also does a lot of community care work, immigration law bits, as I understand it. But a lot of work in quarter protection, so has a specialism, I think, in supported accommodation and hoarders. He's going to be covering the things we're getting rid of, basically. So the abolition of Section 21, what that means, the abolition of the fixed term tenancies, and all the changes in that's going to follow from that in homelessness and deposits. Cara is going to be our last speaker. We're really, really lucky to have Cara. She joined our team formally, I think, last year, but was a pupil with us before that, and has already done some really excellent work in defending possession proceedings. And that will be because she was a duty advisor for a long time before coming and joining us. So she will be dealing with, if I get it right, the duties of landlords, the decent home standards, so all the new sort of regulations that are hoping to make landlords a bit more regulated and a little less, I would say, criminal. So I'm going to start with David. You ready?
I'm ready. So if I get... Oh, that's not where I was supposed to be starting, I think. Well, look, let me just follow on from what Mary said before I get into talking about the actual the bits that I'm supposed to be talking about. This and it's right. This is not just about Section 21. The bill itself is something like 126 pages long. And let me just get my notes. 146 sections, 6 schedules, 230 pages, and it makes absolutely massive changes to the 1988 Act and the 2004 Act. And also to supported housing, which we're going to talk about next week. In terms of the private rented sector generally, from where I sit in my sort of academic ivory tower, we talk about different sort of categories of landlords. So there's the business landlord, but there's also the amateur landlord. And most landlords only own less than 5 properties and come into the sector very much without knowledge of it and just seeking to turn a buck. For me, when you sort of think about the bill in the round, what is happening here is it is the end of the amateur landlord. We're talking about moving towards a much more professionalized private rented sector. I think that is the aim of the government. Alongside that, you've got again from the work that we've done around local authority enforcement of housing standards. There's a wide range of different practices out there. I think we all know that, don't we? But there's quite a predominant number of authorities which we class as being compliance oriented. They want to work with the landlord. Well, here we're moving towards a very different settlement, and that is one that is really going to be something quite important. I think the other thing, and this is why I'm slightly disappointed not to have my slides, because there was a slide, Dominic said Wales doesn't matter, and actually Wales really does matter, because there are provisions in the bill which apply the provisions to Wales and Scotland. And if you ever do any work in Wales, this is quite a big deal. This is a constitutional issue. This is legislation being done in Westminster that is going to affect us in Wales. And I can say us because I work in Wales, even though I can't get my head around the language. So when I was doing training for local authorities and facing the bill for the first time, the way I thought about the bill and the way I cut it up in my head was there was stuff about before the tenancy, about the grant of the tenancy, and about ending the tenancy. That's kind of very rough cut, and I think that's what we're kind of working with here. And today, as Mary says, we're going to talk about before and the grant. But of course, I suppose the other thing, just by way of context, is that where we are right now with it, we've had the House of Lords returning the bill to the Commons, and disagreement over some amendments. I know somebody I was talking to the other day, there's that big obsession, I don't know why, amongst policymakers about pets. I really don't know why, but a lot of policy talk happens around pets. But the idea is that it's going to go back to the Lords in mid-October, and royal assent circa November. That's when they want it done and dusted. Then there's implementation. The landlords I know are talking about wanting 12 months for implementation. My understanding, I mean, it's just random gossip. My understanding is that the housing minister wants it in as soon as possible. But roughly, somebody said to me the other day, April next year. That was their best guess. But there we go. That's my preamble, and I've probably taken up far too much time with that. But I think the policy behind this is really interesting, and where it comes from, and that kind of what I would call Butsker-like politics. But anyway, so let me get on to the actual the slides themselves. The first one is about discrimination. So landlords and those acting on their behalf, thank you, are not allowed to discriminate against a person with whom a child lives or may live or visit, and people in receipt of social security. And that is in terms of, and it's specified as when a person makes inquiry about a property, accessing information about the property, viewing the property, entering into the tenancy, and any term which says that you can't have a child or whatever, or you can't never be in receipt of social security. And I've seen so many of those now are of no effect. Unless, and this is, it's a proportionate in respect of the children one, it's a proportionate means of achieving a legitimate aim, or in relation to social security, again, proportionality. But if there's an insurance requirement, if the property insurance essentially says that you can't have a child there, or you can't have somebody with social security in receipt of social security there. So there is that. The other important thing, I think, is the requirement on the landlord, once you have an agreement, to give a statement of certain terms. That is subject to regulation power, so there's going to be regulations on what terms you have to provide. The other thing about this bill as a whole is just, I haven't, my IT skills are not that good, and so I haven't been able to do a search of how many times the words financial penalty is used, but it is throughout. It's massive. So, and these are all subject to a civil penalty for failure. And some of the civil penalties are on the balance of probabilities, and some are beyond reasonable doubt. So do I press that again? The other thing is that all landlords, this is a regulation making power, but the idea is that all landlords will have to be members of an approved redress scheme. So this is a way for the housing ombudsman to, I guess, increase the scope of their jurisdiction, and all residential landlords will have to be members of that scheme. And again, financial penalty and criminal offence. It's also my terrible typing. That is not Welsh database. This is, I think, they call it the database, but really this is registration. Registration and licensing, I think, of landlords. Well, it's not just registration probably, but the idea is that all landlords will have to register as such, and they won't be able to act as landlords unless they have an active entry on the database. So it is, in fact, again, like Wales. And the idea is that, like Wales, the MHCLG are going to use it to push information at landlords as well, and training. So again, it's a way of professionalizing landlords. Again, civil penalties, etc. One of the important things, though, is if they grant a tenancy in breach of this, that tenancy will still be enforceable. But they won't be able to take possession other than through ASB grounds. The thing that's also had some traction, I think, in the media, in the kind of media I read at least, this is about proposed rent. So landlords must advertise properties at a specific amount. That is going to be called, and it is called in the bill, the proposed rent. The idea being that you cannot basically rent at a higher rent than that proposed rent, and also it's to stop sort of gazumping and that sort of thing of rents. And they can't accept a higher rent or encourage a higher rent than the proposed rent. I think this is my last slide. I'm sorry if I've gone on. And this is about unlicensed HMOs and dwellings. To me, this is selective licensing. This is just tidying up some of the difficulties that have been experienced under the 2004 Act and specifically around rent-to-rent schemes. That is, I guess, quite a big deal. I think that was me. Oh, I've got pets. I knew I had to do pets. Yes, it will be an implied term of every tenancy that a tenant may keep a pet if they ask the landlord, not to be unreasonably refused.
You're delighted by it.
It's whatever. So somebody said to me the other day that actually, you know, when you do surveys of tenants want to keep pets, and that's what comes back. So it's a response to that. That's the kindest thing I can say about it. But honestly, the provisions are quite technical and detailed, and it's going to be hard to enforce. That's me. Thank you.
Now on to Dominic.
Thank you. Right. First, if you have a platform, you have to defend your reputation very quickly. Sorry, 2 seconds. First, delighted to be called very senior, and delighted that wasn't followed by the word moment. Secondly, Wales does matter, just not for this seminar, because we're not dealing with Wales. So, bits I'm dealing with. It's grant of tenancies, and to some extent, Marie has completely stolen my thunder by mentioning the 2 big provisions that are changing. But before I get onto them, can I just look at the policy objectives? So David has mentioned some of them, but in the context of granted tenancies, I wanted to mention a few. Firstly, we are talking about an effort to stabilise tenure, particularly for families. We are talking, as David described, about building a better class of private landlord. We're talking also about a better quality of housing in the private sector. If you can't evict somebody because they're taking you to court for disrepair, you're going to have to do the disrepair. And there's also lots of other provisions in terms of decent home standards. We're also talking, if you look at some of the provisions of the Act, about the continuation of a commercially viable private rented sector. This is not an attempt to destroy that sector. So firstly, the government is concerned about supply, and there are lots of provisions in the Act about ensuring that supply doesn't suddenly disappear. We've heard about rents. If you have assured tenancies which continue forever, you've got to have a means of increasing the rent to a market rent. And there's clear provision, not rent control. It's in fact making sure that rents can still be market rents, notwithstanding assured tenancies existing. And there are some provisions about repairs as well. There are also a lot of provisions here, really nitty-gritty provisions, where the Act tries to, as it were, find the line between security and not security, and where should it be. And in thinking about where that line should be, the government clearly wants to continue and ensure that there is a continued supply in some specialist sectors. And 3 of them would include supported housing, the care sector, 2nd, student housing, and 3rd, key worker housing. There are others which I'll come to, but those 3 are particularly important. I'll explain that and develop that. So although my section is about grant of tenancies, it is also about trying to work out what the government is seeking to do in terms of security tenure, bearing in mind that there are these specialist sectors where supply could be destroyed by the removal of ASTs. So first headline, you've heard it from Marie, but let's go through it quickly. Abolition of a short hold tenancies. ASTs are gone. Whole of that part is removed. There are no more demoted tenancies. They're gone. All existing ASTs convert to assured tenancies on commencement. There are some transitional provisions. An assured short-hold tenancy will survive if there is a valid Section 21 notice that has already been served, and then only pending the conclusion of proceedings. That means proceedings that have been issued, or proceedings that are issued, but if they're issued, they must be issued within 3 months as a maximum of the commencement of the Act. There are some other provisions which relate to the notices themselves and maximum period after notice has been served, but the maximum is 3 months or a very slightly shorter period. The devil really is in the detail. I'm not going to go through it. Check the provisions, okay? So the landlord has a time limit for using that Section 21 notice, and after 3 months, they really are gone. Once the proceedings end, which obviously could take more than 3 months, any tenancy that survives, i.e. there's no possession order, survives as an assured tenancy. So we are really going to see the wholesale removal of assured short-hold tenancies. What about the abolition of the fixed-term assured tenancies? That's the big second headline. No new assured tenancy can be a fixed-term tenancy. Can I emphasize, no new assured tenancy can be a fixed-term tenancy. And all existing assured, I should have put, fixed terms become periodic. So this is only about assured tenancies, as a consequence of which the focus is very much on whether a tenancy is or is not an assured tenancy. And for that, we have licensed tenancies to think about, but we also have Schedule 1 of the Housing Act 1988. So raft of provisions that stay in Schedule 1. Previously, the principal exclusions that we all know about, Secure, Rent Act, business tenancies, those all remain excluded. Other exclusions remain, some have been removed. But the 3 headline changes, as it were, in terms of Schedule 1 is firstly, fixed-term tenancy over 21 years will not be assured. And any tenancy granted between 7 and 21 years, which was granted prior to the commencement, in fact, it's commencement plus 3 months, but any tenancies granted prior to commencement, which are between 7 and 21 years, will also not be assured. So those are the 2 exclusions which are now put in as a consequence of there no longer being assured fixed-term tenancies. So there are some exclusions. There's a third one which is worth noting. Does anybody know what a regulated home purchase plan is? No? It's a form of rent to buy which is principally, it's intended in fact to be compliant with Sharia law. Effectively, there's no borrowing involved, but eventually you get to own the property by paying a rent at a certain rate. So those 3 changes, those 3 additional exclusions are worth mentioning, and it really is about whether it is an assured tenancy or not. If it is, cannot be for a fixed term. Oh, it's nothing like pressing a button and nothing happening. So, second slide. Previous fixed terms, you're going from a regime where you had fixed terms that existed, and suddenly they're disappearing and being converted to periodic. So, what's the rent? When did the tenancy start? Those sort of questions can suddenly be really important. And first rule is previous fixed term tenancies converted to periodic are treated as a single tenancy. The MHCLG guidance. I am so old that that particular acronym has changed so many times that I'm completely lost as to what it means. There should be no two-tier system. This is not a situation like the rent acts and then the turning into shorts, where rent act tenancies continue. We still see rent act tenancies, even though it's I don't know how many years since they disappeared or you couldn't grant them anymore. But the principle here is there really should be no more ASTs existing at all, no more fixed term tenants existing at all. So existing ASTs, fixed terms, and indeed old style notices all disappear. It's all under the new regime. No period of an assured periodic tenancy can be greater than 1 month. So no quarterly, yearly tenancies. The dates that the date that the rent is due must match the period of the tenancy. If you've got a weekly, fortnightly, or monthly tenancy, or 4-weekly tenancy, it's got to match. And there's a new formula for working out what the rent is if those periods change. So if the periods don't match the fixed term that existed before, then you use the formula to work out what it should be if it's monthly. Any terms requiring more than 1 month's rent in advance are void. And that's, again, to do with, David sometimes describes as the gaming provisions. It's to do with making sure that a tenant can't come in and say, well, all right, you can't ask me for more rent, but I'll pay you 6 months up front. Can I have the tenancy? None of that's precluded. There's a short period where you can pay your 1 month's rent in advance. That's between signing and actually getting the tenancy. So those are some of the changes that come from getting rid of fixed terms. I've mentioned some of the potential consequences, and I just again want to put the context in. Maybe I'm hammering this a bit too hard, apologies if I am. But periodic tenancies have existed since time immemorial. It is quite a step to suddenly remove them. And there are going to be all sorts of domino effects as a consequence of that. And the Act has got to catch those dominoes before they unravel. Short hold tenancies have been around since basically 1981. Don't ask me for the exact date. But the Housing Act 1980 introduced those. That's a long time. The lack of security of tenure, particularly with regard to Section 21, was an economic drive. It was part of the Thatcher Revolution, if anybody can remember her. Right to buy, home ownership, buy-to-let mortgages, removal of rent controls, all fit around that removal of security of tenure. And as a consequence, over the last 44 years, many sectors have become structurally dependent on ASTs to ensure their supply, to make sure they can do what they intend to serve in some cases a public good. And interference with these two big changes, periodic and short hold tenancies, has an impact. And so much of the RA, as I said earlier, is about retaining lack of security for some sectors. And this detail is detail that you need to know in order to work out or defend at the door of the court your client. So generally, there are two new grounds which come in, and that's grounds 1 and 1A, Schedule 2 of the Housing Act 1988, and that's family needs and the need to sell. Student accommodation, a raft of provisions excluding some student accommodation, new grounds of possession. Homelessness, temporary accommodation, Section 193 accommodation, there are changes and other changes, and supported housing and the care sector. And just in case you thought that's all I was going to say, bad luck, I'm actually going to take you to some of the detail. This really will send you to sleep. So, subtenancies. What happens to a landlord who is himself a tenant and his head lease says, you shall not grant any assured tenancies or any fixed terms for more than a year? On the conversion of your subtenancy that you've granted, does that mean, on the conversion to an assured non-AST, does that mean that on the commencement of the Act, you're immediately in breach of your, and you're going to lose the whole lot? Well, the answer is no. So there is a transitional provision. It applies to prohibitions in leases, tenancies, mortgages, and insurance products. It's not just head leases, it's mortgages as well. It's insurance products. We'll cover your insurance, but only if you're your landlord insurance, but only if you're granting an AST. So all these provisions have an impact or are impacted by the Act and could potentially put a whole load of people in breach. Answer, any prohibition will not apply insofar as it is inconsistent with the new rules under the Renters' Rights Act. Any conversions are not a breach. Tenancy deposits. Why do tenancy deposits have to be messed with? Because in practice, social landlords never asked for deposits, therefore that sector never took deposits, wasn't covered by it. And secondly, the way the scheme worked is that it's aimed at private rented sector landlords. The mechanism for targeting them is, well, we all know they grant ASTs, so that's how the current legislation works. It targets assured short-hold tenancies. With the abolition, the scheme now applies to all assured tenancies. Sanctions for non-compliance is very similar. So the claim for a penalty, no practical change, it still covers all assured tenancies. However, new Section 215, there is no right of possession on any ground, any Schedule 2 ground, so the only grounds left, if failure to comply, unless that ground is an ASB ground. That's 7A and 14, one mandatory, one discretionary. That's a pretty powerful tool. We've got used to, with tenancy deposit schemes, counting the number of grants and re-grants there have been, and then totting up ×3, ×15 tenancy agreements. That's a big figure. Fantastic. Please pay me this sum. That still applies potentially, although bear in mind that there won't be any new tenancies being granted, or unlikely to be any new tenancies being granted, so you probably only get one going forwards. There may be ASTs previously where they should have registered the deposit and where there's a breach, so you can probably still rely on AST breaches from the past. What you can't do, however, is say, right, well, this is now an assured tenancy. You granted the assured tenancy back in 2008, let's pick a date that would matter, and you should have asked for a deposit, you should have registered the deposit because it's now an assured tenancy and there was a grant, etc. Not retrospective. It only applies to new tenancies new assured tenancies going forwards. So that's the tenancy deposit schemes, just need tidying up, working out. But the big news is that Section 215, if there is a breach, no right to possession on any ground. Just look at home assist briefly. And again, here, I don't agree with this, but the government thinks, and every government that's ever been thinks, that all Section 193 accommodation should be insecure accommodation. That's not 188. It's not so insecure that you're not even occupying a dwelling such that you can be evicted just by changing the locks. Nevertheless, so they do need to get a tenancy agreement. They do have some security because it's a tenancy. Do have to go to court. But there are a number of changes involving. Firstly, threatened with homelessness. Section 8 notice is all that is required to trigger the 56 days, no longer reliant on Section 21 notice. There are harsher consequences if the applicant fails to take steps agreed in a personal housing plan. Must do the steps that have been agreed in the plan. If you don't do the steps, you get given a warning. If you don't do the steps, you then get notice that your duty under the old law is downgraded from a 193 to a much lesser 6-month tenancy or 6-month equivalent tenancy under section 193C4, I think. That disappears, and effectively a failure to comply with the agreed steps now results in no duty being owed. So much harsher, and that is, I think, quite a big change. Of course, all Section 193 discharges must now be, even into the private rented sector, must now be of a short tenancies, not a short hold. So that is a big change that I think will give some assistance, but what you give with one hand, you take away with the other. Before I deal with the taking away, let's just deal with Section 195A. That's the duty where if you lose accommodation that you obtained in discharge of the 193 duty, if you come back within 2 years, you didn't have to be in priority need. Well, now that all tenancies are going to be assured, there's an expectation that you don't need that provision anymore, so it's been repealed. 193 accommodation, because it's going to be granted as assured, does have theoretical security of tenure, but there's a new mandatory ground, 5G. So what they give with one hand, they take away with the other, and you can see government is delineating that line so that if there's a Section 8 notice and you occupy the property pursuant to a 193 duty, or in pursuance of, I think the words are, and the local authority give the landlord, not you, but the landlord notice that the landlord can now go ahead and evict, or put it in statutory terms, that the accommodation is no longer required for the purposes of the Section 193 duty, i.e. do as you wish, then that landlord has 48 weeks in effect to serve a Section 8 notice. And of course, Section 8 notice will also have time limits, admittedly a year, but still time limits, to evict. So there is a time limit in which this ground can be used, but it's still quite a generous time limit. And most landlords who are providing accommodation for local authorities are on a bit of a churn. They're not going to wait 48 weeks unless they like the tenant. So the security of tenure is theoretical for those who are being provided accommodation under 193. The procedure certainly changes, but I think it's still fair to say it's theoretical. Let's look at student accommodation. When I went to university, I did mention the very senior moments, didn't I? When I went to university, I had a block and I was put in student accommodation, and that block was owned by the university I went to. I don't know how many here know who your landlord was when you were in student accommodation. And was that landlord an institution or an educational institution? Those put their hands up are going to show their age. It's a big business now. It is, there are purpose-built blocks owned by private companies. There are HMOs, and there are private landlords who buy houses, buy flats, and use them as HMOs for students alone. And the current legislation is limited in the exclusion of security of tenure. So there is a paragraph 8, but it's mainly about exclusion from security in relation where the landlord is related to or is an educational establishment. Ground 4, there is a very limited ground that allows you to use accommodation for non-students for a brief period of time, and they get it back for students if you're a landlord. So very limited exclusions. The private sector market currently works. It has a massive churn, and it works because of a short-haul tenancies. That is the means by which that churn occurs. And it is a necessary churn. The stats for London, as an example, there are 400,000 students in London. That's a big number, probably close to 500,000. Probably 120,000 of those are new every year, and 120 disappear off somewhere else. So there is a need for a supply of accommodation for large numbers of people going into towns, some towns dominated by universities, Durham being an example. So the government has still trying to ensure that landlords are more responsible than they have been, but they have carved out a limited security or reduced security for students. They've done it in two ways. Firstly, paragraph 8 is changed substantially, and it will include an exclusion from tenure where the landlord is a member of a specialist housing management code of conduct. Those regulations aren't in, but the idea is responsible landlords will be awarded with the ability to move people on. They still would have to go to court, but they won't have assured tenancies, will be common law tenancies. There's also a new ground 4A for landlords who aren't in that scheme or in any other scheme or have any real responsibility, although they will be on the database register, whatever you want to call it. But those landlords will be able to re-let accommodation each year between, I can't remember quite the time, September and November or September, December. And they will be able to do that even though they are not, as it were, kite marked by any scheme. So the fear here, put bluntly, was that the supply for students each year would just disappear and suddenly students would be unable to find anywhere to live. No idea if that fear is justified, but that's the intent behind it. What about consequences for supported housing? What does supported housing mean? Well, statutorily, it means granted by a social landlord to a tenant receiving care, support and supervision. And again, it's a sector which has developed through assured short-haul tenancies. And it requires not a churn so much, but it requires flexibility. Sheltered housing, shared housing, resident carers, sometimes 3 or 4 people in a house with 3 or 4 carers managing them all, sometimes 3 or 4 carers with one person, such as the needs of that particular person. And the way that they do it is they go out and they take a property from the private sector, then they grant it to the person needing assistance, and that person then claims housing benefit. So there are these schemes which revolve around assured short-haul tenancies, and the reason why they revolve around short-haul tenancies is because many of these schemes have only limited funding, or they have to survive financially in order to make it work, or they're stepping stone accommodation. New grounds of possession, there are 4 really, I'm going to say 4. 5E, keeping supported accommodation let to others in the ring. So accommodation that you want somebody in, but you haven't got any support, you haven't got anybody who fits the bill. But when you do need it for somebody who requires support and care, you want to get it back. 5F, and 5F is enormous, but it's effectively designed to allow providers of supported accommodation to continue to function as they do now. So they can claim possession according to need. If somebody doesn't have a need anymore, they can be moved on according to their behaviour. In supported accommodation, the proximity of supported accommodation, one person whose behaviour, even if it's not their fault, but one person whose behaviour is just unmanageable, creates chaos elsewhere. if it's stepping stone accommodation, the lack of engagement will impact. Or it could just be they don't have any funding. How many people know about their local authorities removing funding 2 years ago? Someone goes, changed their entire portfolio of properties, I think, as a consequence of a load of local authorities saying we haven't got that money anymore. Consequently, we can't support you with whatever it might be, a halfway house or whatever. 5H is specifically about stepping stone and lots of conditions. And then there's a new ground 18. So this is the only discretionary ground, recovery for non-engagement with the support being offered. Lots of detail. Seminar 2. I'll try not to make it quite so dry, I promise. I know you've got time. I've got I think one more. I've got tied accommodation, very similar. Tied accommodation used to be about I'm providing you with this accommodation because it's a necessary part of the work that you are doing. Caretakers is a classic example. Tied accommodation now is far wider. It's about jobs markets, lack of affordable housing. So in this instance, it's about keeping, there are 4 grounds, changes to grounds and 3 new grounds that are specifically aimed at ensuring that accommodation can be used as a perk of the job to get people in. It can be used for low-income workers, can be used for key workers or specific professions. And those professions can be anything that that local provider thinks is important. So a lot of flexibility, again, detail in the second seminar, but tied accommodation has a lot of new grounds where security tenure is excluded, so as to allow that workforce to be developed in local areas. Apologies for taking so long, and thank you for your patience.
Right, now on to Cara, who's going to talk to us about regulating these landlords.
Can I have the yes, thank you. Hi everyone. So I'm going to be talking about some of the provisions that will affect how these tenancies run during their lifespan. So the first one, oh, I need to do on here, sorry, is there's now some anti-gaming provisions within the legislation that are going to be inserted by clause 15 of the bill. And they're effectively designed to stop the landlords from doing some of the things that we see them doing at the moment. So there's 5 things that are now prohibited. Firstly, purporting to let a property for a fixed term. Obviously, as Dominic discussed, that's gone now once the bill's been implemented. Secondly, they're prohibited from purporting to bring a tenancy to an end by service of a notice to quit. Thirdly, purporting to bring a tenancy to an end orally. Fourthly, serving a purported notice of possession, and that's defined within the bill and will be inserted in a new section 16N of the Housing Act. And finally, relying on a ground in the new Schedule 2, where the landlord doesn't reasonably believe that he'll be able to obtain an order for possession on that ground. In terms of what happens if a landlord breaches those prohibitions, the local housing authority can impose a financial penalty if it's satisfied beyond reasonable doubt. So it's the criminal burden of proof that applies to these breaches. It's important to note as well that it's slightly different in respect of E, which was where they rely on a ground in Schedule 2 where they don't reasonably believe they'll be able to get possession on that ground. In those cases, they can only impose a financial penalty if the tenant actually surrendered their tenancy without an order for possession following service of that notice, within 4 months of that notice being served on a ground they didn't have reason to believe. How this will be enforced, we'll have to wait and see. How will you be able to prove they didn't have reason to believe? These are all issues that we're going to have to grapple with when we're dealing with enforcement. In terms of how it will actually be enforced, you'll need to come to part 2 if you want to hear about that. I'll be talking all about enforcement by local authorities at that one. And in respect of how the landlords can actually get possession, Dominic and Marie are going to go through all of the grounds for possession at the next seminar. So make sure you sign up. It's on Thursday next week. The next change that applies during the tenancy is effectively the implementation of AWAB's law to the private rented sector. So that will amend Section 10A of the Landlord and Tenant Act so that it applies to all tenancies for less than 7 years. Now, it's interesting because obviously we don't have fixed term tenancies anymore, although some of them might stick around, but periodic tenancies, surely they'll all be for less than 7 years. They'll all be running month to month, week to week. And effectively, as I say, it implements AWAB's law, which is currently being implemented in the social sector into the private sector as well. And we've got some draft regulations as to what that might look like. They're called in social housing because when they started, it was only intended that AWAB's law would apply to the social sector. So we'll need to see if any changes happen to that. But the plan is that there will be phased implementation in respect to the social sector from October 2025, initially only in respect of damp and mould. So it may be that if it applies to the private sector a bit later than that, we'll have different implementation times. But again, we'll need to see how these regulations are tweaked in respect of the private sector, or whether there's going to be completely new regulations in respect to the private sector. What is also exciting is that there's provision in the bill for AWAB's law to eventually be extended to licenses, so not just tenancies. Now, it's a power, it gives the Secretary of State a power to make regulations specifying what licenses AWAB's law will apply to. There's no draft regulations at the moment which show that the Secretary of State's planning to do that. This may become one of those provisions that just sits there in the Housing Act doing nothing, as we're all too familiar with. But again, we'll only know, time will only tell in terms of if this is something that the Secretary of State decides to do. The next change in terms of during the tenancy is the implementation of the decent home standards to qualifying residential premises, which are defined as dwellings under an assured tenancy or a rent act tenancy, HMOs, and supported exempt accommodation, unless they're provided by a private registered provider of social housing, because they're already subject to the decent housing standard. So this is effectively extending it to the private rented sector. Yeah, it won't, the specific regulation in the bill and the amendments to the Housing Act won't affect the social sector, but they're subject to it anyway. Next, rent increases. So this is a change, but it also isn't a change. So it amends Section 13. Now, we're all quite familiar with rent increases under Section 13, and it tweaks a few things about it. The main one being that now 2 months notice of any increase has to be given. So that's longer than before. And it seems that the only way now that rent can be increased is through service of the Section 13 notice, and then there can be subsequent actions following service of that notice. So it may be that it's referred to the tribunal for determination, and following that determination, the rent can be increased by the tribunal. It can also be increased by agreement between the landlord and the tenant following service of the Section 13 notice, if they agree an amount of rent that is lower than what was in the Section 13 notice. So there's an ability there between the landlord and the tenant, perhaps to avoid having to go to the tribunal to agree a lower rent than what was in the notice, or they can agree that the rent stays the same. Also, they can do that following a determination by the tribunal. So the tribunal might say, market rent is this, and actually the landlord and tenant can agree an amount lower than what's fixed by the tribunal. But effectively, all rent increases will have to be through Section 13 and then one of these agreements afterwards, or determination by the tribunal. In respect of what can go to the tribunal, the tenant can either challenge the validity of the notice or the amount of the rent increase. So it's going to be interesting to see if there's an increase in work in the tribunal, and also how they're going to be determining rent increases. And again, you should come to our part 2 seminar next week, because we have the president of the First Tier Tribunal Property Chamber coming to talk about how she thinks that tribunals will be approaching determination of rent increases under the new regime. In respect of social tenancy, Section 13 doesn't apply, but there is going to be a new Section 13A for rent increases in the social sector, and they'll be required to give 1 month's notice of any increase, and it refers to a prescribed form. Now, we don't know what this prescribed form is going to look like yet, but it can be expected that that's going to exist. This section also specifies that the rent can be increased yearly, and it will take effect on the date specified in the notice, again, unless the landlord and tenant agree a different variation of the rent or agree that it's not varied. So we've got, again, this ability to try and have some negotiations. It's not just Section 13 notice is served, either take it to tribunal or there's nothing that can be done. You can have some negotiations about how much the rent should be increased by. And this is particularly relevant in the social sector because social tenants don't have any right to apply to the tribunal, unlike private sector tenants. Finally, the change during the tenancy is in respect of the tenant's power to end the tenancy. Now, as I say, I'm not going to go into the landlord's powers to get possession. That's dealt with in our seminar on next week. But in terms of notices to quit by tenants, there's been some changes in terms of the fact that the tenant can't be required to give more than 2 months' notice. Sometimes we have tenancies where you have to give ridiculous amounts of notice if you wish to end your tenancy. And also notice can be by any written means. So any provision in the tenancy agreement which says it has to be in a certain form, that won't be of any effect. Also, interestingly, and probably quite helpfully, when you have clients come to you where they've taken some steps before getting legal advice, they can withdraw their notice to quit at any time before it takes effect. Obviously, before the position was, the notice has been served and that ends tenancy. But now they can withdraw it before the date given, which can be helpful when you've had a client sort of upset by being served with a notice or something like that. Just say, oh, I don't want to live here anyway, and serve a notice to quit, when actually they have a defence of the claim. It's salvageable now, so that's really helpful. I think those are the main changes that will apply during the tenancy. At our next seminar, there's going to be some discussion about how landlords can end the tenancy, but also enforcement of some of the provisions that we've discussed today. And I think that's it from me.
Amazing. Okay.
That was necessarily, I think, really, really thorough and detailed. I guess it's going to come to life as we start to deal with it in our cases, but it's really helpful to have all this information for now. Are there any questions about that huge amount of information that's just been dumped on you? I wouldn't be surprised if there isn't. There will be in the future.
It all feels a bit abstract now, doesn't it? Like
It is. But yeah, you can see how all of these things are going to start coming to life. Oh dear, it's from Zia.
Well, not really a question. I'm even older than Dominic, and I remember when the 88 Act came in, it was like a real sort of wow. And then I think the litigation about the 88 Act finished in about 2000. And then the 96 Act amended a bit of the 88 Act, and that took another 5 years to resolve. We're still arguing about what the Housing Act 1996 means in 2025. I hadn't really appreciated the depth of and the breadth of these changes. But this is a staggering reordering of the private rented sector. The biggest one, I think, I've seen since Rent Act tenancies ceased to be. So when you had Rent Act tenancies, it was very difficult for landlords to get a possession order. They were like hen's teeth. They were very rare. And that sort of thinking of the courts carried on even when the assured tenancies came in. And judges were anxious, in my experience, not to evict people. And then over a series of cases from the Court of Appeal, the pendulum swung, and then you had a short all tenancies, and now possession orders are easier to get. Perhaps I should say that. It seems to me the pendulum is going to swing again. And if you're going to have professional landlords coming in and sort of amateur landlords being driven out, what does the panel think? And perhaps those of us, those of you who are nearly as old as me, do you think we might go back to how things used to be in terms of possession orders being fairly difficult to get?
I think that's a preview for next week.
Yeah.
But Dominic, you give us.
There were two themes in there. One was, I think it was a very selfish theme from Zia there, which is there going to be much litigation in this? The detail of the provisions. I gave you some of the headlines on even just assured tenancies, fixing rents that where there's a conversion, the possession orders, the Schedule 1 exclusions. They are all about that long on the page. You will really want those provisions. There are 4 main acts that get amended: the 88, the 96, 2004, and I think the Housing and Regeneration Act. And those acts will all appear in books, and you will have them to hand, and you will be looking at that detail. And I think that the opportunity for interpretation and which way it goes, there is going to be plenty of litigation. On the second bit, when we take that litigation, what are the judges going to be doing? I think the judges at any level, particularly at county court level, depending on their sympathies, there are certain judges I can think of who definitely won't change. But most judges are going to get that the intention of this is to rebalance. And as David said, to create a more professional landlord cohort. The degree to which they, as it were, flow quickly in that direction or not, I'm not sure. But it is a statement, the Act. It's absolutely a statement that people should not have their lives disrupted just because of complaining about, I don't know, disrepair or whatever it might be. And I think that is really important. So I hope that sea change happens. I can definitely see some judges picking it up more than others. You'll all know your local courts, and you all know which ones are likely to go one way or the other. But I would anticipate that sea change. If we think about the Equality Act for a moment, and those cases that said, you know, there is intended to be a sea change in the introduction of the Equality Act provisions, it did take. I mean, we have a 2010 Act, but there was a 1990-something, 1997 Act before that, and it did take some time for people to change. It was quite a few years before we even had a defence on the basis of Equality Act in the reasonableness case of a secure tenancy. So I think things will take time, but I do think, and I hope, for obvious reasons, that the pendulum does swing. And the academic on the panel might have something else to say about that.
Yeah, it's an interesting question there about court proceedings. I mean, can you imagine once the Act comes into force, going into your first duty possession hearing and presenting to the judge that actually, well, there are these transitional provisions, and I'm going to be the, you know, I don't know what I'm going to be, but I'm perhaps in a slightly better position than other deputies. It's going to be really tough. I mean, it's going to be tough for you presenting and tough for the judges. And I can imagine, you know, the threshold in 55.8 being met on numerous occasions. So there's going to be consequences, I think, for possession days and for, I guess they might have to rethink the court forms, possibly. I'm not entirely sure. Yeah, probably. Yeah, Marie says they will. So I'm going with Marie. I mean, it will be mayhem for a bit, and it's going to be tough, I think, for everybody. The idea, I think, is that the ADR stuff is going to kick in. Certainly, that there is that sort of feeling that sort of Gove had, and that I think has carried on, that somehow we can resolve all of this without necessarily us lot in this room. Which of course we know is no. I can't think of a nice word to say. So yeah, I mean, I think it's going to be massive, really difficult litigation, as Dominic says. This stuff is really complicated. It's perhaps more complicated at the moment because it's sort of you got to read it over from the bill to the 88 Act, and when we see it in its glory, it might be a bit easier. But at the moment, it's like it is befuddling. That's my view, and I'm older than both of you, so I can say that.
Even if parts of it aren't complicated, bear in mind the number of provisions that say you must do Act 1, Act 2, Act 3, or Step 1, Step 2, Step 3, Step 4 before you have a grant, and a date by which that has to be done, or a notice that needs to be served beforehand, or etc. So there is opportunity, I think, for landlords getting things wrong simply because whilst they may become a professional cohort, they aren't necessarily there at the moment. So not only the duty advisor deserves sympathy to some extent, or rather no, does deserve sympathy, but perhaps the landlord to some extent deserves sympathy for having to then work out exactly how to deal with all of this. But that's to our advantage.
I'm quite excited to see the new ways they're going to get things wrong, because if they still can't get the grounds from 1988 right,
Exactly.
they're going to be making
Yeah.
a whole new range of mistakes. It's going to be quite fun, I think.
I'm hoping it's just going to be much more expensive for them because, as you say, 55(8) is going to be met a lot of the time.
Yep.
Summary possession order is going to be pretty hard to get unless you're in hundreds of thousands of pounds of rent, or a little less. But so I'm hoping that just puts all these professional landlords off, but it won't. So we'll still be busy. But they will.
Yeah, and it may be that we're busier with longer cases if people are getting less sort of easy possession orders. But I mean, it's just going to be the Section 21 stuff that's gone. Landlords are still going to want their properties back. We know what they're like. So they're going to try and twist the grounds to make it work in a way they want. But that's why we've got those helpful new prohibitions, anti-gaming stuff that we can also throw at them. So there's maybe new things that we can be annoying landlords with as well.
There's two questions online. One is, what will the burden of proof be for landlords using families and needing to sell ground? We'll cover that next week. But burden of proof is still balance probabilities. But it's going to be, again, just to look at the complexity of it, it's going to be quite interesting in terms of proof of evidence. There's an expanded ground where you can have all sorts of relations who are connected, or partners of relations, or relations of partners. And you're going to need to prove all of that as a landlord, and you wonder whether somebody is suddenly going to magically become a partner of somebody else, and yes, no, this really is X, Y, Z. Those kind of relationships are going to become really important to prove, and equally to defend. And the degree to which there are sham attempts in those circumstances, it will be quite interesting. Another question very quickly. You mentioned that the landlord will be limited to asking for 1 month's rent in advance. However, some local authorities offer 3 months' rent in advance or more as an incentive to landlords to rehouse clients. How will this be affected? So the assured, if there's a discharge in Birmingham to a landlord who at the moment would grant an assured short hold tenancy for a period of 2 years or whatever it might be. And yes, they do take from the local authority a premium to grant that property to those off the housing waiting list rather than to local individuals in that area. So although the rent is still a housing benefit rent, the landlord gets an extra fillip, as it were, because he gets 3 months' rent. I can't see how that would continue. No. I think that system is going to stop, and it is, in a sense, it is. I think that fits with the purpose of the Act. Although there's limited security of tenure if, for instance, somebody refuses a property, a Section 193 property, or refuses an offer under Section 193. I think there is an intention to prevent, the continual rise of rent through demands from landlords who have local authorities, as it were, exactly where they want them. So I do think that there is an intention to try and restrict those practices.
Although I think that if you've got to advertise the rent, you're going to advertise it as high as you can
Exactly.
possibly go. And so
And
that is going,
bidding war
to,
anyway. Yeah.
I don't know what Siobhan's going to say next week, but I think that is going to skew the way the tribunal considers rents. And that's
Yeah.
without wishing to prejudge it or anything like that.
And there was one provision which, so under short hold tenancies, you could, nobody did this, by the way, but you could challenge the rent that has been set. You could take that rent to the tribunal and say it's too high rent. I'm not aware of any tenant who ever did that. Of course, because it would mean that the landlord would probably get rid of you at the first opportunity. In this case, where the landlord cannot get rid of you in the first opportunity, those sections have gone, of course. They've been repealed. So I think David's right. It'll be interesting to see what happens with rents and whether people just put in incredibly high figures. Apologies.
Okay. I think we've got time for one more question because lovely David's got to go and then I've got to release you all. Sure. Sorry. And if you could introduce yourself into the mic, that'd be lovely.
First of all, thank you very much indeed for all your information you gave. I better introduce myself very quickly. I'm 75 years old. I've been a solicitor 55 years and a deputy district judge for 25 years. I'm now retired, but still practicing part-time. I've always been interested in housing law, and it seems that my question is this, that there's a raft of regulations, as you know, EPCs, gas safety certificates, all sorts of things, which are actually very important for tenants defending possession proceedings. How are those regulations still going to be in force, or is there any kind of change to those regulations? I'm thinking of.
So they're really important, aren't they, when you're dealing with 21 notices?
Yeah.
But we don't have Section 21 notices now. So yeah. I mean, but I guess that it goes to local authority enforcement as well.
Yes, I was going to say I might
yeah.
address that at the next
Right.
seminar. I don't have an
So
answer
come
for you
next
now,
week.
I'm afraid. If you come on Thursday, I'll make sure to specifically address it.
If we cancel that seminar, we didn't know the answer.
Yeah.
I mean, I find local authorities just don't want to spend the money, so they don't want to get involved.
Exactly.
But no, that's where I fundamentally disagree. Okay, and I fundamentally disagree because once they levy the civil penalty charge or the financial penalty, whatever you want to call it, they get that money is ring fenced for their housing enforcement practices.
Oh yes, in the future, yeah.
So,
In the past,
I mean, they right now.
Yeah.
So there is a massive incentive on to them, about which I've written, of course. But
Thank you very much.
Although much of this will be covered next week, to my mind, there is a real change in terms of the expectations on the local authorities. I think so. Although we lose the ability to privately police through Section 21 notices, whether or not a gas safety certificate, though we don't really care whether it was enforced, we just want to know it wasn't so that we can avoid possession. But although there's that sort of theoretical enforcement for a number of those provisions, I think that local authorities, so it's part of their remit, and I think that the Act does increase the expectation on them. There's been discussion in chambers about the degree to which we might start judicially reviewing failures to take action to try and, as it were, break up the cosy relationship between local authorities. If there's a default, many local authorities simply say, well, we're going to give you an advisory letter, not a notice, just a letter. That sort of step Is that something which we can now say, no, 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 you need to be much more proactive. You need to be serving a notice immediately. That kind of JR that might
Yeah.
come about. And my sense of it is that there might be a change. Discussion for next week, but who knows, maybe another sea change.
Thank you very much.
I mean, Section 21 isn't a good way to enforce compliance with gas safety requirements anyway, because we all know that landlords won't have done any gas safety checks for years, and then you raise it as a defence to a Section 21, that claim's resolved, but then they just do finally do one gas safety check and then start another claim for possession. That's not quite, I think, what was intended with the gas safety regs, which was to make sure every year this property is safe for people to live in. So I don't think we should be too worried that it's not going to be raised through the Section 21 procedures anymore, because that wasn't a good way to be dealing with this anyway.
Yeah.
Right. Thank you. Sorry, I've just spoken over you. I think, thank you everybody for coming. David's got a train to catch, so we really must go. But everybody's, please feel free to stay after for drinks and ask us any questions. You just can't ask David, sadly. But thank you for coming, and thank you to our speakers.